May I just answer all of them? Lord, whatever is going on in Supreme Court, Lord, I have the privilege to appear in all the matters. I know what is going on there.
So, but one thing, if the writ petition is disposed of, then how these orders could be passed?
Was it disposed of? So more fundamental question. It was not disposed of. Kindly see the order passed in the writ petition. And that's why the learned judge says, Lord, what Lord, in other agency records saying disposed of is not disposal.
Mr. Bhattacharya, a lease has to be decided on the basis of what I allege and what is denied.
No, Lord, this has been decided by the division bench of this court that this is a public employment. The constitutional court, when finds there is some serious irregularities in public employment, constitutional court can go beyond that. This is decided by coordinate bench of this court and not has been challenged. Therefore, repeat it. Then I would have to place all the orders passed by the division bench from time to time. Therefore, the division bench will have said, if the constitutional court finds that something is wrong, seriously wrong in the process of public employment, then the court can go beyond the pleadings. Something is called implied pleading. On the basis thereof, what did the court do? Court only directed to publish it. Whatever the records you have with your appointing authority, School Service Commission, court did not come to any independent finding. Court has directed the School Service Commission, that's why I placed the order, that whatever you have found, you publish it. The only apprehension which is genuine, Lord, I accept, that before any order of termination is passed, they should be given a hearing. That is the only genuine approach that can be appreciated. But they want to avoid the court. There was no disposal of the writ petition. And even if it is assuming the learned judge was then considering 3 applications filed by other parties. If the parties come and appear before, they say, for the purpose of transparency, everything be disclosed. Why should somebody be affected? The writ petitioner did not get something for her own personal benefit. She suffered. But she wanted to know that why these discrepancies coming tip by tip. Let it be disclosed in totality. That was done.
But 261 is the answer to Mr. Bhattacharya. Page 261. That is the answer to Mr. Bhattacharya's argument. Page 261.
Regular bench 11-12 matter already waiting for the outcome of Supreme Court.
I appeared in this matter.
Regular
Same
bench.
chair, until August. I appeared on
Regular bench Justice Basu.
It is been adjourned till August. They tried there.
Kindly see.
Failed and went there.
Kindly see the case status, case disposed. This is Lord High Court's website. And Lord, in a disposed of writ petition, so many applications have been filed, out of which some are disposed.
But we should not go by the website. We should go by the order.
It's a part of the High Court.
Can file
In a disposed of writ petition. Can file in a disposed of writ petition.
I cannot even go and seek for addition of party there. আচ্ছা 11 তারিখের অর্ডারটা দেখান আমরা এটাতে অ্যাডিশন অফ পার্টি চেঞ্জ
one is the case status matter, server matter, and the order referred to dated 15th of May, matter will find it at page 238. Reading of the order at 238 matter, it does not reveal matter that the case has been disposed.
What remains? That is what I'm saying. This is respect.
So the writ petition matter seems not to have been disposed of. It seems to be an inadvertence matter.
16 তারিখের
Just it.
I was trying to indicate that since procedures are being harped upon, an appeal is a continuation of the original proceeding, but neither the CBI nor the ED, despite being party respondents, they have been their names figure in the array of parties. So the appeal in its present form is not maintainable, That is what I was trying to indicate. But I come here, because I have been served with a copy of the appeal by Mr. Lahiri. We have received it yesterday in the second half only, but I do not know, whether, for whom, we are here. I was there for the CBI, before the honorable single judge. But as on date, in the appeal, despite we being parties, in the writ application, in the original proceedings, the names do not figure, in the array of parties.
They were not parties.
This has happened because they are not.
But they were added as parties.
We are not parties to the
They have
prayed for leave to prefer an appeal.
We have
but
got, there may be procedural defect.
No, we've got the
If your
restriction
lordship
from
wants to
Bhattacharya.
kindly direct us, we will.
Kindly seize the
We'll regularize.
cost at 139. They are not parties.
Bikash, power share.
We have got it from
We'll add them. We didn't have
Page
it for cost
136 is the
But
cost.
if they are genuine candidates, they shouldn't have so much of apprehension. Apprehension itself indicates that they are not genuine candidates.
Babita Sarkar to fraud.
Yes, that I say. That many frauds are coming. Then why should not the total list be published?
Not make such submissions.
Lord,
Page 178.
We are afraid of the procedure.
The cost title of Babita Sarkar. Page 78. Kindly seize.
Lord, we are not, Lord, on the cost title.
We'll add them.
Mr. Bhattacharya, I always want to make him happy. Lord, we'll add them as well.
you have both sides.
Both sides. Both sides.
Both the extreme.
We'll make both of them. We'll make both of them happy. Lord, kindly grant us leave to prefer the appeal. And I am told, Lord, the regular bench has not adjourned this matter relating to 10 and 11 teachers publication till the matter is decided by the Honorable Supreme Court. That matter is coming up in August. Dr. Patro is appearing there. Your Lordship can add.
Several matters.
Mr. Bhattacharya, what do you say to this? Because Supreme Court has fixed this matter. Similar matters, only the years are different.
Yes.
So should not we wait for till the Supreme Court takes up this matter? Because
In respect of the termination, Lordship, I have agreed to it may be given, they may be an opportunity, but there cannot be stay for the publication of the result. The client judge has directed. That is not in any way affecting their right. Supreme Court is concerned only to the issue whether they should be given a hearing before the termination or not. That's the issue before the Supreme Court, nothing else. Now, to that, they are trying to develop a case. OEMR sheets is recovered from private agency. Therefore, whatever numbers we have got, those are genuine. This is their defense.
But that issue is also before the Supreme Court.
No, not at all. Issue is only whether they are right to hearing before termination. That they are building up their defense. That defense is something else.
In the SLP, that ground is not taken. In the SLP, that ground is not taken.
Although they say, no, the only ground that we have been working for 5 years and we are genuinely appointed. Cases where the School Service Commission, the appointing authorities admitted that there has been OEMR manipulation. What else to be decided? But the Honorable Supreme Court is going into the issue of question of natural justice. Lordship will give that protection that they should be heard before termination order is issued. I think that's good.
You have admitted that there has been manipulations.
Lord, we have admitted
that there have been manipulations. That is what Mr. Bhattacharya is saying.
What has happened is CBI retrieved the hard disk from the agency which was engaged by.
Give an answer first, then you.
In a way, we have admitted. In a way, why we verified the record given by the CBI with our records, and the discrepancies were revealed, and we have stated before the court against whom these discrepancies came out. Those are the candidates who we are now being directed to upload their names, their list, etc. Though when
whose names you found to have been manipulated.
Yes.
This will be the list.
Yes. Now,
so that is based on certain data.
Yes, it is based on the hard disk which was sent to us by the CBI. That we have cross-checked with our.
It's on the basis of the hard disk.
Yes, that we have cross-checked with our database.
In a way, better for you to know that whether you figure or not.
Lord, this is Lord one of the issues which are pending in the Supreme Court. Please come to Lord page
even if
190.
it is published and your services are not terminated till the Supreme Court proceedings are decided.
Kindly Lord come to page 197. Kindly see Lord this issue is directly involved. This is the division bench of the matter, which is the subject from which the appeal is pending.
No, your SLP, what is a
SLP? I don't have a SLP copy, but I can show your Lordship that it has a direct nexus. Please come to page 197. This is from the division bench. Now, please come to the third paragraph. Similarly, has your lordship got that? The requirement of proof under 65B in regard to the particular nature of procedure is a requirement which can be satisfied at an appropriate stage and not fatal but curable, etc. So, Lord, this was not only argued in extenso, but this is, Lord, also the issue before the Supreme Court.
That is a writ petition saying that declaration. This is subject matter of challenge before the Supreme Court in Gopinath Bhanjaj. Next page.
And in fact, page 202, your lordships will find this is the judgment which is impugned before the Supreme Court.
So this appeal is pending.
Yes,
Appeal
this
is-
is those
this-
matters.
Those matters. From this appeal, the matter has gone up.
No, so the appeal was
Appeal
not,
is disposed of.
appeal is not disposed of.
One appeal disposed
One
of,
appeal has been disposed of. One appeal has
There were
been
three
disposed of. There were three appeals. One has been disposed of. The others are pending.
In one matter, the declaration was that OMR sheets are. This is also issue. Page 152. Declaration to issue that the purported OMR sheets published under notice are not conclusive and the subject matter of proof before the following due process.
Please come to page 152.
This was a writ petition which was being considered in
No,
the
but
petition.
you have challenged this order before the Supreme Court.
Lord,
Against
we
which-
have not. The affected parties have. We are similarly
Oh,
situated.
you mean this affected
Yeah.
parties there?
The transfer petition is pending. There,
Lord,
issue
kindly come to page 152. This was the prayer in the writ petition, which is the
in this
subject
case.
matter is the
Division.
special leave petition.
page 150.
Kindly see prayer B.
There was previously
That is the
direction.
reason why I am humbly praying, Lord, that kindly, Lord, stay the process of this publication till the matter is finally decided by the Supreme Court. Whatever, Lord, the Supreme
But
Court
the Supreme Court, is it deciding also this issue?
Yes. No.
Yes,
Yes.
if your lordship wants,
I will
I
go.
can
I have annexed the writ petition.
If your lordship wants, I can produce, Lord, the SLP copy. I don't have it today with me.
In the SLP, this ground is taken.
No, but I don't know the ground is taken or not, but they are trying to argue this point. It's admitted position. They have been trying to argue this point that these OMR is as if it is a criminal trial, therefore OMR sheet should be proved in the criminal court. That's the tenor of argument. But in case of appointment, below the prima facie material which discloses that the appointing authority admits these are all manipulated. Therefore, below, this has nothing to do with criminality, and the argument which they have been trying to advance to the Supreme Court relates to criminal law, not with the below, appointment which is governed by Article 14 and the rules.
But it's one thing that so far as the
But even then, Milord, even if the Supreme Court considers the publication, Milord, is not in any way affecting the issues to be decided by the Supreme Court. Publication, Milord, really make the issues precise. We can get to know who are the ultimate persons to be given hearing.
Court will know who is
there has to be a finding because this issue has been raised in Gopinath Bhanjaj's case, the writ petition at page 134.
Yes.
An issue has been raised that a declaration to issue that the purported OMR sheets published under the notice are not conclusive and are subject to proof. So if they are not conclusive, then what would happen? So
That has to be not. This might be argued, but the OMR hard disk is conclusive without any doubt in mind, and that is accepted by the employer. The School Service Commission, by filing affidavit, says yes, we have compared. There has been manipulation. That is affidavit before the division bench of this court. But I would like to place the affidavit. Therefore, so far the appointment is concerned, this is conclusive.
But why the School Service Commission has said?
Yes, in an affidavit filed by the School Service Commission, even before the Supreme Court, that Mr. Dr. Patra has argued that you have compared and we found this manipulation.
Yes, Dr. Patra, have you said so?
My lord.
What Mr. Bhattacharya is saying, was it your stand before the Supreme Court also that you have compared and found it to be manipulated?
My lord, what has been submitted in the Supreme Court, I don't know.
No, but Mr. Bhattacharya said.
What?
But we have filed affidavits, that is correct.
Yes.
We have throughout submitted, and even in some of the cases filed affidavits stating that yes, we have compared and there are manipulations, and that we have admitted. Up to that extent, we have admitted. We have also admitted in the affidavits that NICER was our authorized agent who carried out the task of evaluation.
No, which affidavit? Can you just show us affidavit that you are?
No, then on the next.
Yeah, we shall hand over an affidavit. Achiki, did also?
They have never been circulated. I have been appearing for 6 weeks, 7 weeks. It is never circulated.
No, it is already disclosed in Supreme Court. In the affidavit, their own paper book, this is there.
No, it is not there.
The employer should be in a best position to say,
yes,
supposed to maintain a neutrality.
I understand.
So if a neutral body has come with a thing,
the employer,
so
what the employer is saying is that as handed over by the CBI, we are doing this.
OEMR sheet may be published, but the authenticity conclusiveness
handed over by the
left
CBI.
open until the matter is decided by the Supreme Court.
That the OEMR sheets. May I just show two orders, my lord. First order is of honorable trial judge saying that the OEMR sheets have been recovered from one Pavan Bansal. Second order, 16/12/2022, where the employer admits that original OEMR sheets have been destroyed pursuant to Rule 21 of the recruitment rules. At that relevant point of time, we have come and said that until and unless this has been recovered from a private individual from his residence. That is what we are saying. Had this been recovered from their own server, I wouldn't have been there. That is the writ petition, saying that the OEMRs recovered from the private residence of a particular person cannot be relied upon until there is a conclusion.
But that's the hard disk. This is not a printout. This is the hard disk.
I didn't want Lakshmi Tunga matter. May
I kindly protect us.
I request your lordship to kindly not decide also the jurisdiction to pass this order.
Lay down.
And publication will be
181 is also taken together.
The order is Can 8 order.
Two applications. Now, because of commonality of the issues, MAT 1302 of 2023 and MAT
My math is 1304.
1304 of 2023 are taken up together and disposed of by this order. The appellants,
Jurisdiction to decide.
the applicants, the applicants in both the appeals. Please tell us if we please on the facts. Please tell us the applicants in both the appeals